Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Welcome to podcast 85, and of course, first things first, Happy New Year. This is a special year, of course, because we are going to get to our 100th birthday, well, at least our 100th podcast in that time. So we'll have to think about how we're going to mark that particular occasion. Thanks as well to the barrister who wrote in saying that he had listened to the podcast while flying at 35,000 feet on his way back from an exotic holiday over Christmas, claiming a prize, saying that this was probably the most unusual place that anyone had listened to the podcast. I have to say, I'm not sure it is, because I remember about 12 months back we had someone who wrote in claiming that they'd listened to the podcast while cycling around India. Which I think probably struck me as even more unlikely behaviour. But I'm very willing to open up a challenge if any listener out there wants to top that in terms of unusual places for listening to this podcast. Anyway, in our first 2016 podcast, we've got three cases, of course, and the first is a Court of Appeal decision concerning the duty to make reasonable adjustments, and the key question is whether employers are subject to a duty to make reasonable adjustments when considering disciplinary sanctions under a sickness absence policy. Secondly, we've got an EAT case considering a claim of unlawful discrimination following a negative verbal reference given by a former employer, which contradicted the agreed written reference. And the main issue for the EAT was whether there was an evidential basis to infer that the former employee's disability-related absences were the reason for the negative reference. Finally, we've got an employment tribunal decision. We don't do a lot of just pure employment tribunal decisions, but this one considers whether the time limit for bringing a breach of contract claim in the employment tribunal, rather than civil courts, is subject to the 6-year limit under the Limitations Act. So, first case, Griffiths and the Secretary of State for Work and Pensions, and this is the Court of Appeal decision looking at whether disciplinary sanctions under a sickness absence policy are subject to the duty on employers to make reasonable adjustments. So, brief legal background. The duty to make reasonable adjustments is found in section 20 brackets 3 brackets of the Equality Act. And that section states that an employer has a duty to make reasonable adjustments where it knows or ought reasonably to know that a person has a disability, and there is a provision, criterion or practice, the PCP, which places that disabled employee at a substantial disadvantage compared to those who are not disabled. In order to establish whether an employer has breached this duty, you need first to identify the relevant PCP and then look at the comparator group in order to assess whether the PCP put the disabled employee at a substantial disadvantage. Background facts are fairly straightforward. The claimant, Ms. Griffiths, was an administrative officer at the Department for Work and Pensions, been there for over 35 years. She was off sick for 62 days due to post-viral fatigue. On her return to work, she underwent an occupational health assessment and it found she was suffering from fibromyalgia, and both parties accepted, of course, that this was a disability under the Equality Act. The DWP has a sickness absence policy which is triggered if an employee is absent for 8 working days in any 12-month period. Under the policy, there is an escalating warning process, beginning first with written improvement and then finally ending in possible dismissal or demotion if the absence continues. The policy is flexible and it allows for discretion to be used in the case of an employee who is disabled. However, this discretion was not used in Miss Griffith's case, and following her sickness absence, she was issued with a written warning. As a result of this, she brought a claim for discrimination by way of a failure to make reasonable adjustments. And the two adjustments that Ms. Griffiths claimed the DWP should have made and would have been reasonable for them to make were: 1. The DWP should have disregarded her 62-day absence on the basis it was an exceptional absence due to her disability. Secondly, she said the DWP should have extended the trigger point under the policy going forward by an additional 12 days. So the absence management policy would not be triggered in the future until she reached 20 days of absence. So, pausing there, it is important to note that Ms. Griffiths only brought a claim for a failure to make reasonable adjustments. She didn't bring a claim under Section 15 of the Act relating to discrimination arising from disability, nor did she bring an indirect discrimination claim, and I'm going to come back towards the end of this report on why that's relevant. Well, case went to the Employment Tribunal, to the EAT, and then finally ended up at the Court of Appeal. The Employment Tribunal and the EAT both dismissed her claim on the basis that the duty to make reasonable adjustments was not even engaged. This was because the sickness absence policy was applied by the DWP to all employees in the same way, regardless of whether or not they were disabled. Furthermore, the policy did allow for it to be applied more leniently to disabled employees. So they found that Ms. Griffiths had been subject to the same sanctions that she would have been subject to if she was not disabled, but had been absent for the same period, and therefore she was not subjected to a disadvantage by virtue of her disability, the ET and the Employment Appeal Tribunal reasoned. Also, both the ET and the AT said that even if the duty had been engaged, the adjustments suggested by Ms. Griffiths were not reasonable. Well, of course, she goes to the Court of Appeal, and her appeal is dismissed. However, this was only on the basis that the adjustments sought by her were not steps which the employer could reasonably have been expected to take. Interestingly, the Court of Appeal disagreed with the ET and the AT in relation to whether the duty to make reasonable adjustments was engaged. The Court found the duty was engaged, and this effectively ends the earlier EAT decision of Royal Bank of Scotland and Ashton, which had taken this idea that it was not engaged. The Court of Appeal accepted there was a PCP which substantially disadvantaged Miss Griffiths when compared to a non-disabled person. The PCP in place here was the requirement to attend work at a certain level in order to receiving warnings and possible dismissal. Here, the PCP was not the policy itself, because the policy did allow for discretion in relation to disabled employees, and it did apply to all employees equally. It's the requirement to attend work that was the PCP. Formulating the PCP in the way that the tribunal had done, i.e. to look at the policy itself, failed to get to the bottom of why a sickness absence policy may, in certain circumstances, adversely affect disabled workers. The reason why disabled employees might be more affected than non-disabled employees is because, due to their disability, they're more likely to be absent from work, more often than a non-disabled employee. Therefore, the Court pointed out it was really essential to formulate the PCP in terms of levels of attendance at work, rather than the policy itself, and in doing so, it found that the duty was engaged, as there was a PCP which put Ms. Griffiths at a disadvantage. However, unfortunately for her, this wasn't enough for her to succeed. The Court went on to find that the tribunal had been entitled to conclude that neither of the adjustments would have been reasonable for the DWP to make. In relation to the 62-day sickness absence, it wasn't reasonable to expect an employer to disregard such an extended period of absence. This was especially because the medical evidence suggested that Ms. Griffiths would be subject to further periods of potentially lengthy absence, and therefore disregarding this period would not necessarily have had the effect of removing her disadvantage. In relation to the extension of the trigger point under the policy from 8 to 20 days, the Court found there was no obvious period by which this trigger point should be extended. The medical evidence had shown that future absences were also likely to be long, and therefore any relatively short extension wouldn't have removed the disadvantage from Ms. Griffiths. This meant that any extension became somewhat arbitrary and of limited value. I think this case is a really useful one, as this area of law was, to be honest, somewhat unclear previously, with confusing and, may I say it, somewhat illogical EAT decisions. So, we've got clear authority that sanctions under an absence management procedure are subject, potentially, to a duty to make reasonable adjustments. And the Court highlighted there could be circumstances, indeed, where a relatively short extension of the trigger point under a policy would be an appropriate reasonable adjustment for an employer to make. For example, if there was a case where a disabled employee was likely to have relatively frequent but short absences from work, the Court of Appeal seemed to suggest here that it was potentially reasonable for an employer to extend the trigger periods so that the employee wouldn't be caught, the disabled employee that is. Of course, this is something that will be considered on a case-by-case basis with the assistance of medical evidence. Just one further point on this. The Court placed quite a lot of emphasis on the fact that Section 15 deals with disability arising from disability, and that wasn't part of this case. Lord Justice Elias was quite clear in his view. Section 15 puts employers under a duty to make allowances for a disabled employee. It would be perfectly open for a tribunal to find that a dismissal for a disability-related absence constituted discrimination arising out of a disability in breach of Section 15. Lord Elias seemed to suggest that if Miss Griffiths had relied on Section 15 rather than the duty to make reasonable adjustments under Section 20, maybe the outcome would have been different. So, following this case, I think it's quite likely we'll see more claims from claimants pleading Section 15 discrimination arising from disability cases, alongside indirect discrimination and failure to make reasonable adjustments cases. As we've seen in 2015, there are more cases already being pleaded on a Section 15 basis, and the courts have shown that this is a relatively low hurdle for disabled claimants to overcome to get their case off the ground, as it were. So employers should be thinking about justifications for decisions under an absence management policy in order to be able to defend themselves. Standing back from all this, I do have a bit of a conceptual difficulty with the idea of employment tribunals wanting to get involved in something as frequent as employers' sickness absence policies, and whether they really are going to be interested in, rewriting employers' sickness absence policies on a case-by-case basis. It's a bit like the cases involving banks and discretionary bonus awards. As a gross generalisation, and boy is it a gross generalisation, courts didn't show a lot of interest for there being an appeal, in effect, against an employer's decision on a discretionary bonus which the employee did not like. Equally here, I can't imagine that tribunals are going to want to get involved in evaluating regularly sickness policy decisions taken by an employer affecting a disabled employee. We'll see. It'll be interesting to see how the courts approach that issue. Anyway, that's the case of Griffiths and the Secretary of State for Work and Pensions. Next two cases, much shorter, I am sure you will be glad to hear. PNAISER, which is PNAISER, and my apologies if I'm mispronouncing that, and NHS England Coventry City Council. It's an EAT decision which considered whether deviating from an agreed reference could amount to disability discrimination, where the former employee alleged that her disability played a part in the negative assessment that was given to her prospective new employer. Under the Equality Act 2010, employees are prevented from treating employees, including former and prospective employees, unfavourably because of something arising in consequence of a disability, unless the employer is able to justify the behaviour, showing it's a proportionate means of achieving a legitimate aim. Well, once the employees establish the basis for their case, it's for the employer to show on the balance of probabilities that their behaviour was not discriminatory. In this case, Ms. PNAISER was an employee of Coventry City Council, and she was disabled. As a result of her disability and the medical treatment she required, she took a number of long absences from work. However, for reasons unrelated to her disability, she was made redundant. She entered into a settlement agreement with the council, and in the agreement there was an agreed written reference. Essentially, it was a factual reference, dates of employment, job title, roles, responsibilities, that stuff. So much, so obvious. Well, no mention was made in the agreed reference to Ms. PNAISER's absence record, and details of her time off work for disability reasons were also omitted. Following her redundancy, Ms. PNAISER applied for a job with NHS England. She was considered to be an excellent candidate following interview and was offered the job subject to references. You know how this is going to go, don't you? Well, on request, the council provided the NHS England with the agreed written reference, and this was followed up with a phone call to the old employer. During the call, the old employer, the council, mentioned that Ms. PNAISER had had significant absences on account of her disability during her employment. It's alleged that the council employee who took the call with NHS England stated that he thought it unlikely that Ms. PNAISER would be able to adequately fulfil the NHS role. And on the basis of that conversation, it appears that NHS England then withdrew the job offer, although there was some dispute factually about that. Ms. PNAISER subsequently brought a disability discrimination claim against both her old employer and the prospective employer, alleging that the negative reference given by the council and the job withdrawal were both unfavourable treatments arising in consequence of her disability. The tribunal dismissed her claim, finding that she had failed to establish the connection between the council's negative assessments and her sickness absence. She had failed to establish a case, and therefore she didn't shift the burden of proof onto either the council or NHS England to prove that their treatment of her was not discriminatory. Ms. PNAISER appealed to the AT, and both claims were ultimately successful. Ms. PNAISER claimed the tribunal had set an impermissibly high hurdle in requiring her to show that the only inference which could be drawn from why the council gave a negative reference was a discriminatory one, with the reason being her level of absence. The AT agreed and held that on the facts it was clear that her sickness record played a part in the negative reference given by the council. It concluded that as those absences were almost exclusively related to her disability, then discrimination arising from disability was clearly established. The fact the council hadn't intended to discriminate when giving this assessment was irrelevant. Instead, the tribunal should have asked why the negative reference had been given by the council, and whether there was enough evidence to infer that Ms. PNAISER's disability-related absences had been the cause for the negative reference. The EAT held it was for the council to demonstrate by now that it had not played a part in its recommendation to NHS England. Equally, the EAT held it was for NHS England to demonstrate that these disability-related absences hadn't been part of its rationale for withdrawing the job offer. The AT found the necessary inferences could be made, and therefore the burden of proof should have shifted to the Council and NHS England from Ms. Peneza. Well, the case highlights issues that can arise for employers, both prospective employers and former employers, when requesting or providing references. Although an employer needs to be aware of a candidate's disability for a case of disability discrimination to succeed, this case clearly demonstrates it's an irrelevant factor for a tribunal to consider whether there was intention by the employer to discriminate or not. Instead, the focus should be on primarily whether the employee provides satisfactory evidence to establish a connection between the allegedly adverse treatment and the disability, such that the burden of proof shifts to the employer. In the context of giving references, new employers need to be really careful to ensure that if they elect to withdraw a job offer already made to a candidate on the basis of a negative reference, that there can be no inference that the reason for the withdrawal was the candidate's disability. To withdraw a job offer where there has been mention of illness or sickness-related absence is potentially pretty dangerous, particularly where those absences are or are likely to be disability-related. Certainly our experience would indicate it's highly likely that a disappointed employee, job applicant, whatever, will look to bring proceedings and ask for disclosure of all relevant documents connected with the recruitment process. We did a case a few years ago for an employer who exited their HR director, and then one of the HR director's former colleagues wrongly told the new employer that the HR director had been sacked for bringing a claim of race discrimination, which was untrue. Lots of litigation after that one. It also highlights the importance of ensuring that the reference request is only to be given by a named person at the old employer. One of the difficulties, of course, is that unofficial references given informally could still be relied upon by the new employer and could give rise to legal liability. I know it's very difficult to ensure that everyone in an organisation who might be asked to give a reference knows if there's an agreed reference to be given. And so if you're negotiating a settlement, it's far better to ensure the obligation only applies if the reference request is addressed to a particular individual at the old employer who you are sure will be on message. So that's the case of Peneza and NHS England and Coventry City Council. So third and final case, Grisanti and NBC News Worldwide, Inc. This is the Employment Tribunal decision which I mentioned earlier, and it held that the time limit for bringing a breach of contract claim in the Employment Tribunal is not, repeat, not, subject to the 6-year time limit under the Limitations Act. Say what? Well, let's give a brief background. Employment Tribunal's Extension of Jurisdiction Order, 1994, provides that in order for a claimant to bring a breach of contract claim in the tribunal, they need to present the claim within 3 months of the date of termination of the employment contract. Fine. In addition, the claimant is prevented from bringing a breach of contract claim whilst the employment relationship continues. Fine. Under the civil regime, the Limitation Act 1980 provides for a limitation period of 6 years from the date on which the cause of action arises. An Employment Tribunal decision in 2012, Taylor and Central Manchester University Hospitals, had held that employment claims brought in the Employment Tribunal were subject to both sets of limitation, i.e. the 3-month window for claims after employment terminated and the 6-year long stop for breach of contract claims. This is only a first instance decision, an Employment Tribunal decision, and there's been no higher authority on the issue. So along comes the Grisanti case. The facts of the case aren't particularly noteworthy, so just very briefly, Ms. Grisanti brings a claim for breach of contract against NBC News following the termination of her employment, and her claim was in respect of national insurance contributions that allegedly should have been paid but were not paid by NBC News into her state pension between 1996 and 2003. Ms. Grisanti brought her claim within 3 months of the date of termination of the employment. However, the alleged breach of contract had taken place over 6 years previously, so the key issue in this case was whether the 6-year backstop under the Limitation Act applied in the Employment Tribunal. Clearly, of course, just pausing there, she couldn't bring a claim under the Wages Act or the old provisions under the Wages Act because the sequence of deductions had stopped in 2003. Well, back to this case. The Employment Tribunal judge held that the Limitation Act 6-year backstop did not apply. And in coming to the decision, the Tribunal found that to place a 6-year limitation on claims at the Employment Tribunal would be unduly restrictive. Unlike in the civil courts, for civil claims, employees have to wait for their employment to end before bringing a claim in the Tribunal. Therefore, the tribunal judge reasoned it would be a fetter on an employee's ability to bring a breach of contract claim in the tribunal if they were also subject to the 6-year backstop. The judge also held that the purpose of the tribunal order was to extend the jurisdiction of the tribunal rather than to limit it, and there is no mention of the 6-year limit anywhere in the tribunal order. The judge also went on to state that he didn't think that the decision would open the floodgates to historic claims, and to that extent I agree. I think there are relatively limited situations where a claim is brought within 3 months of termination of employment, but for a cause of action that arose more than 6 years ago. In my experience, most breach of contract cases are in respect of causes of action that arise around the same time as the termination of employment, and so this wouldn't be an issue. Clearly, this is an employment tribunal decision, and having looked at matters carefully, it's come to a considered view. I think, however, that my take it is fundamentally a very odd idea. If the basic 6-year backstop, which applies in the courts, does not also apply to historic claims in the employment tribunal. The 6-year backstop is there for a very good reason, namely to prevent stale claims coming to court when it's difficult for them to be evaluated fairly by a court. Don't see this as any less of a feature of civil courts than in tribunals. Or the other way around, I should say, not a feature of tribunals any less than civil courts. Arguably, indeed, since it's expected to be speedy, cheap and informal access, etc., it's even more important that disputes are dealt with on a prompt basis. So I think overall it is a pretty surprising suggestion that the employment tribunals can consider breach of contract claims which are dead and buried in any other civil court. For employers, this is clearly a bit of an unwelcome development, and certainly if you're acting for an employee on an exit, it may be necessary now to go back and ask some quite detailed questions as to whether there are any historic contract claims around which can now be resurrected on a termination, perhaps as a bargaining chip to negotiate a higher severance payment. Who knows? Anyway, so that's the case of Grisanti and NBC News Worldwide, Inc. So finally, I just wanted to say, for those who've not yet seen it, we did a really useful summary at the end of 2015 in a document form of all the cases we considered on the podcast during 2015. I will put a link up to that on Twitter, which, for those of you who haven't yet subscribed, Nicholas Robertson at Nicholas ROBER11. And equally, if you subscribe to the LinkedIn group, we've posted it on the LinkedIn group too. It's well worth having a look at. It was a really, really good document put together by Kanan Twory, who, of course, appeared in our Christmas special podcast. So, that's all for this episode. Thanks very much for listening. And as always, I can confirm that no employees were harmed or injured in the making of this episode. Thank you.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.